Welcome, thank you for joining us for this dive into data protection. What we'll be doing in this webinar is giving you a roadmap to help navigate some of the changes in data protection law that we see on the horizon. So some of these issues are still up in the air, but what we'll be doing is giving you the background context and also flagging where we think developments will go. My name is Liz Bradley. I'm a senior solicitor in the employment team specialising in data protection, and I'm joined by my colleague
Jacob Montague, a solicitor in the corporate and commercial department, regularly assisting Liz and our other employment colleagues, helping our clients navigate their data protection obligations, whether this be through data subject access requests or international data transfers.
So what we have seen this autumn are three major consultations in the data protection world, and we will be taking you through each of those varying levels of detail. So the first one is the ICA's consultation on international data transfers. The second one we'll be looking at is the update to the Employment Practice Code, which was published in November 2011, so definitely due an update. And the last one we'll look at is the government's consultation on data and new direction, where they're basically setting out their thoughts about our data protection regime and the direction it might go in now that we are on our own, so to speak, after Brexit.
So, data sharing and the latest ICO consultation. The sharing of personal data is now a necessary part of our personal and professional lives. Many organisations now process, control and share huge amounts of data, largely for very, very legitimate reasons. In an employment context, this could be with regards to financial data that may assist payroll, or perhaps medical data, which obviously in light of the recent COVID-19 pandemic has become a particularly sensitive and difficult area to navigate. Companies will probably also be processing a huge amount of customer and client data, whether this be through the ordinary course of business or through marketing campaigns. This growth has led many organizations to start outsourcing their data protection obligations, and therefore struggling to analyse the flow of the data. It's obvious that sharing data will have significant economic and social benefits, including job creation, efficient delivery of public services, and even improved customer experience. However, it becomes very difficult to navigate the flow of data. And the ICO Commissioners, or the ICO, the Information Commissioner's Office, has provided some guidance to assist organisations in doing this. One is the data sharing hub that they've created. This includes a lot of very useful documents, such as the data sharing myth busting tool, but also the data sharing code of practice, which became legally enforceable on the 5th of October this year. Essentially, these documents provide a very nice and general overview of the GDPR principles and essentially helping organisations stick to their data protection obligations by using data sharing agreements and also basically just getting into good practice. However, a key sticking point for many organisations is restricted transfers, and essentially this is where personal data is being shared outside of the protection of the UK GDPR. I'm now going to hand back over to my colleague Liz to explain a little bit more about restricted transfers.
So what are restricted transfers? Well, restricted transfers are basically where we are moving data to a third country, and the regulation talks about third countries as being the places that are outside of the scope of the legislation. So previously, under EU GDPR, that was outside of the EEA. Now, because we're under UK GDPR, we actually mean anywhere outside of the UK. So it's a much wider pot, basically, of transactions that could be a restricted transfer. And that's why we do need to be a lot more conscious of where data is moving now, post-Brexit, than we previously had to be. So once we've identified whether or not we're dealing with a restricted transfer, what's the issue, what's the big deal? So basically the rationale for restricted transfers is to protect people's data wherever in the world it goes. So it's important to remember that GDPR thinks about data as a fundamental human right. So that's really the mindset that the legislation is written with. So the idea behind having restricted transfers is to basically prevent people who hold data from moving it anywhere in the world so that they can do whatever they want with it outside of the legislation. So it prevents commercial misuse and it prevents state interference. Those are the two key issues that restricted transfers are supposed to be combating. And it basically means that we're dealing with a legislation that views moving data suspiciously if it's going outside of the scope of the legislation. So that's the thing to bear in mind. Restricted transfers are not permitted unless, so the default position is they're not allowed unless you can do them the right way. Doing them the right way has become more problematic, and that is because of a ruling called Schrems II, which you will probably be familiar with, but we do just need to give the background just so we all know what we're talking about and we're all on the same page. So Schrems II was the result of a data activist basically challenging the validity of data transfers to the US on the basis that those transfers put people's data at risk of being interfered with by various US authorities. So it was a big kind of surveillance, anti-surveillance case. And what it did was to challenge two things: Privacy Shield and also SCCs. So Privacy Shield was the framework that we had that declared data protection standards essentially equivalent if a company had signed up to the guarantees under Privacy Shield. So they would be saying that we'll handle the data in a certain way, and the European Commission had gone, tick, yes, that's fine. What the litigation did was to invalidate Privacy Shield. So the court took one look at it and said, no, we don't think these standards are sufficient. You can't use this framework to say that the data is going to be safe in the US. So we no longer have that option. We don't have that adequacy framework that we can rely on, which means we need to be using appropriate safeguards instead. And our appropriate safeguards that we've tended to use have been SCCs, so standard contractual clauses. And unfortunately, Schrems II also challenged those. They didn't invalidate those standard contractual clauses, so we can still use them. But we got saddled with lots of additional work to do to make sure that data protection standards would be upheld using the SCCs. We have to do risk assessments, and we have to put in place supplemental measures if there are risks that need mitigating. So that's what the litigation told us. What it didn't tell us is how to do those things. We really didn't have any guidance on a practical level about what it would mean to comply with these new requirements. So this is where we've been for a little while now, and as some of you will probably have experienced the pain of that fumbling around trying to figure out what on earth we're supposed to do now and what we can rely on and what we can't. So this is where we thankfully, hopefully, have some salvation coming from the ICO. This is what they've been consulting on with the International Data Transfer Consultation. So what they are looking to do is to provide us with some guidance, some support, and some documentation to make sure that when we do international transfers, and particular transfers to the US, we know that we're using the right level of agreement and we're doing the right level of risk assessment to help make sure that the data that's moved to the US is going to continue to have the right level of protection.
As Liz mentioned, part of the consultation is actually how to interpret the GDPR definition of restricted transfers. And the consultation is very useful in this, in that it provides vital insight into how the ICO is trying to analyse this complex area and therefore try and steer us to what we can actually expect to be included in the guidance. For example, it is the ICO's preferred option that in order for a restricted transfer to have taken place, there must actually be a transfer from one legal entity to another. The example the ICO gives is that it would not be a restricted transfer where data flows within a legal entity. For example, it wouldn't be a restricted transfer where one employee takes a laptop outside of the UK, or a UK company shares data with one of its overseas branches. Similarly, the ICO is also proposing that whilst a restricted transfer would take place when the GDPR controller or processor authorises an overseas legal entity to process the data, it would not if it was the overseas entity only contributing to the data flow. I understand that that is, quite a complicated series of examples I've just given, and we can expect fairly detailed guidance on this, which will help organisations map their data transfers against the guidance, rather than having to sort of puzzle over the various ways we can interpret the UK GDPR.
And it is really helpful because, as Jacob has indicated with those examples, it can really be getting into the weeds of what a restricted transfer is, on exactly which entities, which scenarios are applicable. So to have some concrete guidance on that will be really, really useful. Another aspect of the guidance is around the agreements that we use when we do know that we're in restricted transfer territory. So as I previously mentioned, we've been using SCCs, and those have been based on the Commission's drafting, which the ICO tweaked after Brexit to basically, refer to the right institutions and take out references to the EU, but didn't do anything else other than that. What they're now doing with this consultation is actually replacing SCCs with a new suite of documents, new acronym, IDTAs, International Data Transfer Agreements, and these will eventually replace SCCs. So actually this is just an area that is, rather than necessarily clarifying things, is basically replacing like for like, and unfortunately creating an area of work for companies, because we will be seeing SCCs phased out eventually. What the ICO is indicating is that once the international data transfer agreements have been laid before Parliament and become official documents to be used, they will allow companies, organisations to enter into any SCCs that were in the works for up to 3 months, and then within 24 months of the IDTAs coming into force, everybody will need to transition across to these IDTAs. And it's basically because of Brexit. We need our own version of SCCs, and that is what the ICO are giving us through this particular set of documents. So they're not radically different to SCCs, they still have a similar format, so you might be familiar with that, where you've got your tables that set out the details of the parties involved, you've got your mandatory clauses that you can't amend, and that's what guarantees the appropriate level of data protection. And then you have some optional clauses and optional space to put in your kind of commercial arrangements. So with SCCs, that's when we would be using the annexes, and it's basically a similar format under IDTAs. So that part of the consultation is basically kind of Brexit housekeeping. It's useful, but it's also work that we'll just need doing in the coming months and years. We'll have to wait for the actual deadline, but that's the ballpark time frame. What is more useful, and I will let Jacob talk us through, is actually some guidance on how to do the kinds of risk assessments that I mentioned Schrems 2 now requires when we're talking about transfers to the US in particular, but other jurisdictions that might be problematic from a data protection point of view.
So, as Liz just mentioned, the ICO does recognise that this is no easy task to conduct a transfer risk assessment, and is therefore sought advice on its transfer risk assessment tool, which forms part of the consultation. The tool works by asking a series of questions, and first off, it should be noted that it's unlikely that you'll be expected to conduct a transfer risk assessment where you are making a restricted transfer to a country that's already covered by the UK adequacy decision or regulation, or if that restricted transfer falls within one of the exceptions. Similarly, it's worth mentioning that the tool is very much geared towards medium to low risk routine restricted transfers. It's not going to be acceptable to use where you are making a restricted transfer to a country which has more than one piece of data protection legislation, or an area that is subject to more than one country's rules. Similarly, it's not going to be appropriate to use this tool where the transfer is to a destination country which has a human rights record which could produce a high risk for data subjects themselves in the context of this specific transfer. Essentially, the tool poses 3 questions that will hopefully assist the transferor, and then each of it follows a very nice decision tree. The first question requires the transferor to understand the transfer. You'll need to consider whether the transfer meets the fundamental UK GDPR principles. Ask yourself, is it a lawful transfer? Is it fair? Is the data that you are proposing to transfer, is it adequate and relevant and limited to actually what is necessary? And you also want to be obviously very, very certain of where the data is actually going and where the importer is located. The second part of the tool asks you to consider the enforceability of the international data transfer agreements that Liz mentioned, actually in the destination country. Careful consideration will be needed to ensure that the level of protection that the UK GDPR guarantees is not undermined once, or even enforceable for the data subjects. Once the transfer has been made effective, and that there are still, good and effective legal remedies available to both the exporter and the data subject. And the final step is to require you to assess the destination country's actual regime for regarding and regulating third-party access to that data. This is mainly targeting data surveillance. And obviously, this is likely to be the hardest of all aspects of the transfer risk assessment. And the ICO does not expect a huge and strong understanding of the importer's data protection regime. It's all it's likely to be taking a good and balanced risk assessment, and hence that's why I mentioned earlier that it's only suitable for low to medium risk transfers. Using the tool should enable you or the organisation to get to a point where you have sufficiently addressed any concerns and can either proceed with the use of the IDTA or, if needs be, conduct a further assessment. Typically, there's not a lot of guidance on what actually constitutes a further assessment, and in those circumstances, we would basically either expect the organisation, the exporter, to get specific legal advice, or to consider maybe restructuring or changing the transfer that will enable it to lower any associated risks. This consultation closed on the 11th of October, and so far we haven't seen any updates or announcements as to when the guidance, the IDTA, or any further legislation will be published. We do expect something to happen soon. However, as with lots of these things, I'm sure you will appreciate, they do take some time.
Great, so moving on then to the ICO Employment Practice Code, and as I mentioned in the start of the webinar, we've been waiting a long time for an update. It actually still refers to the Data Protection Act 1998 and was pre-GDPR, so it's still really useful, but it's definitely time for an update. And what this consultation, this survey, was looking for was basically for as many people as possible from across the data users, data subjects, companies, advisors, to just put their thoughts forward on what guidance would be helpful and how the ICO can basically better support us as we navigate things that weren't even contemplated when the first code was drafted. So the code is in 4 sections, and I think from the consultation it seems like they're basically planning to keep that format, but we'll have to wait and see. So the first section is recruitment and selection. Then it also looks at employment records, looks at monitoring, and it looks at health and employers holding health data, which obviously post-pandemic, or if we're in the pandemic, it's become a much more relevant area, in a much more complicated area than was previously envisaged. So it would be really good to get some new guidance on that. I was actually part of a working group with the Employment Lawyers Association contributing to the consultation, which was a really interesting perspective just to hear from different advisors, different perspectives on the areas that we feel like would be most useful for guidance. So I can just flag a few of those. Obviously, we don't know how the ICO is going to take on board our comments, but I can just kind of let you know some of the areas that were up for discussion so that you can also be aware that these are probably areas that if you're not thinking about, you should be thinking about, and possibly, you know, reaching out for some legal advice and some support in dealing with. So there have been obviously a lot of social and technological changes in the time since the first code, and really what we were doing was going through and basically flagging where there are contradictions between different levels of guidance and different practice that we need the ICO to clarify on. And one of those areas is special category data. We obviously know that that is treated with a greater sensitivity within the context of UK GDPR. But now, given various social changes, whether that's to do with diversity and kind of an increased focus on understanding diversity within the workforce, or whether that's, like I mentioned, the pandemic and holding more health data, employers are collecting a lot more data and collecting data in quite unstructured ways as well. So it might be that you are asking in kind of equalities questionnaires for this kind of information, but it might also be that people are just disclosing it as part of general communications within the workplace. Or it might be that you're starting to think about ethnicity pay gap reporting or various other levels of kind of understanding your workforce, where you're starting to hold more of this data. Also things like criminal records. We've got various different pieces of legislation that have a bearing on how and why you might collect criminal record information, and some of those pieces of legislation conflict. So areas like that have been flagged to the ICO as points where we really just would like some clarification. I don't know if any of you are in the financial services, but being regulated by the FCA and being required to report on ethnicity and those sorts of things versus the ICO's position. It's just a few areas where actually some reconciliation between the different areas of guidance would be helpful. So that's something that has been flagged to them. Another area is to do with automated decision making, and this is a relatively under the radar section of GDPR that people tend to just make blanket declarations about. We don't do this. Often in your policies it will say we don't make automated decision making. And it's partly because the definition of that within the regulation is quite complicated. It's hard to know whether you're actually falling within that. It's a kind of significant level of decision making without human intervention. And generally people tend to think, we've got enough human intervention that we're probably not within this bracket, but it's not that clear. And I think given the increase in things like, AI and the use of kind of external providers to help with recruitment process outsourcing, just there's more and more technology involved in a lot of decision making, whether that's at the recruitment stage or it might be to do with like selection for promotion or those sorts of things. But actually making that blanket declaration that you're not doing ADM is probably something that now needs thinking about. But how to think about that and how to actually understand what the regulation calls ADM is not that clear. So that's another area that we've kind of flagged to the ICO and said, help, please, help. So we'll see what they come out with on that. And it's those sorts of issues, and it would be a webinar in itself to go through it in lots of detail, but it's just to flag that the ICO are due to publish a new code. Unfortunately, we don't know when. The consultation closed end of October, so I think it will probably be New Year before we hear anything. But these are areas that are worth thinking about just in terms of your own best practice, and also worth knowing that we will hopefully get some additional support on. And then the last area that we wanted to talk about was the government's consultation. So I will let Jacob start us off with that.
So our final subject of today is the government's recent consultation on its policy paper, Data, a New Direction. Many of you will remember that last year the government published its National Data Strategy, and this detailed 5 challenges or missions that it believed it needed to overcome in order to basically take the whole advantage of the opportunities that data presents. This latest consultation is basically about how the government will seek to tackle the second of these missions or objectives, essentially securing a pro-growth and trusted data regime. The consultation, which finished last week, covers a wide range of topics, but resounding theme of removing barriers and burdens, ensuring better flexibility, and hopefully providing greater clarification for the UK's data protection obligation, are all very much big parts and to the core of this consultation. One area in particular they're keen to discuss is the accountability of organisations. It believes that the EU's GDPR has created a sort of box-ticking compliance regime for organisations. And the government believes that this sort of one-size-fits-all approach will actually has the potential to discourage innovation in how to achieve the actual goals of using data responsibly and protecting individuals' rights. Furthermore, it often the government seems to think that it involves unnecessarily high costs that are associated with this GDPR accountability. This leads me very nicely into the topic of subject access requests, which were also discussed in the consultation, which, as I'm sure many on this webinar know, is a very costly and hugely burdensome, often task to undertake, which has often disproportionate burden on costs and an organisation's resources, in particular in an employment context, for example, where an employee has been there for a significant amount of time. To combat this, the government has asked for views on whether or not to introduce a specific fee regime similar to the one already in place with the Freedom of Information Act. This could allow essentially organisations to charge or even refuse requests based solely on the anticipated costs of dealing with it, which is obviously good news for controllers, but does not necessarily align with the spirit of data transparency. Similarly, the government would like to introduce a new data protection compliance process where the obligations will actually be on the data controller to have a clear and precise procedure to follow that the data subject will have to follow, and this would actually mitigate the need to contact the ICO. Again, this seems to be slightly more in favour of data controllers, and some have viewed it as limiting the right to data subjects.
Yeah, so we can see from that overview that the government is definitely exploring new options now that we aren't so tied to the EU in the way that GDPR has operated in the past. But I think it's worth recognising that there are still implications. We have our adequacy decision, which is in place until the 27th of June 2025, and that is a fixed end date, but it also has the potential to be reviewed at any point in time if the Commission thinks that we're drifting or we're doing something that they're not happy with, that they feel is undermining the level of protection required by GDPR. So in terms of data flow and the government not wanting to do anything that would mean we'd be isolating ourselves from being able to be within an adequacy umbrella that would keep data flowing across Europe, there are some checks and balances that will probably have the effect of putting the brakes on in terms of what the government will actually end up proposing and doing. But it's just worth noticing that there's definitely potential for talk around a different way of approaching data protection now that we have the capacity to legislate that for ourselves. So it's definitely a wait and see on that one, but it's worth just being aware of the fact that the landscape may not stay in the way that we've become used to with the influence of Europe.
So, in conclusion, and sort of to sum up the last 30 minutes, where we're aware we've given you a huge amount of information to digest. A lot of it as well is slightly speculative. We're working on, based on the proposals and some of the consultation responses. We will, of course, endeavour to keep you as updated as we can as and when we get new concrete information. In terms of how you can, based on what we've said, how you can continue to meet and better understand your data obligations, data protection obligations, a huge thing that we regularly recommend to our clients and our partners is data mapping, ensuring you have a good understanding of exactly where your data is going. Understanding it right from the very much, in an employment context, understanding it right all the way from recruitment all the way to exiting the business, having a clear and understanding and easy to follow data map of where your data is flowing will be hugely crucial and critical and important in anticipation for the legislation and guidance that we certainly expect to see in place in 2022.
And following on from that, just reviewing your partners, being aware of who you're outsourcing your data to, and also who they're outsourcing the data onto, their sub-processes and what jurisdictions that is involved in. And just, again, it goes to that point of knowing the detail, because obviously if you don't know where it is, you don't know how it's been protected. So just having that level of oversight about the data that you are holding and passing on to other parties. And I think I would just finally say that we do need to just keep one eye on the ICO. Part of the government's consultation always was to actually suggest some potential reforms to the governance of the ICO and to the way it might work. And the ICO predictably have pushed back on some points where they feel like their independence is being threatened a little bit. But I think we will definitely see some changes. We already know we're getting a new commissioner from January. So there will be changes at the ICO, and obviously changes could potentially mean the landscape of enforcement changes. So I think that's just something to be aware of. We've had a regulator that's tended to be quite pragmatic and not necessarily that proactive when it comes to enforcement, but a lot of the things we've been talking about do have very high enforcement penalties if we get them wrong. So if we do end up with a more proactive and more empowered ICO, then obviously we will all need to be more careful. And on that note, we are more than happy to support you. Our contact details are the slides, which will be circulated to you all as part of the follow-up. And we just thank you for your time and look forward to working with you in the future.
Thank you for listening. If you have any questions at all, please do get in touch.